Amazing. Okay, so we're going to be doing a recap on GPSR because we're coming up to almost a year since it was implemented. So we know that a lot of businesses have come across us. We've done a lot of webinars and presentations and so on, but we still feel that there's probably a lot of companies out there that are still either unaware of the regulation or unaware that it actually impacts them, and some may be kind of stumbling blindly into non-compliance, which obviously we don't want. So we're going to do a quick recap, and hopefully the overriding message from this session today is you will all, broadly speaking, be compliant with GPSR already. GPSR is really a documentation exercise. It's about demonstrating that your products are safe for consumers, even if you're selling them via distributors and resellers. The fact is they're going to consumers in the end. But everything that you do as businesses here in the UK, we don't make unsafe products, we don't sell unsafe products. So it's about gathering all of that documentation to prove that our products are safe and making that documentation available to the authorities as and when they need it. So if there's a product safety issue in the market. Okay, so via means of a very brief introduction, I'll cover off where GPSR sits in the EU regulatory landscape. We'll talk about why, in its wisdom, has the EU Commission decided to introduce GPSR now when it's all been working absolutely fine to our knowledge. We'll talk about the products that are within scope, and I'll draw your attention to some notable points within the regulation because, to be honest, EU regulation, global regulation as a whole is so it's almost gobbledygook sometimes. So you'll hear certain terminology, certain phrases, and you're scratching your head thinking, what the devil does that mean? So I'll cover off what some of those may be. And then very helpfully, EU regulation does break down your obligations for compliance depending on the role that you play within getting that product to market. So whether you're a manufacturer, whether you are a distributor on behalf of a manufacturer and you're selling those goods into the EU, but they're not your goods, you're simply distributing them. And regulation breaks down your obligations depending on that role that you occupy. So I'll cover that off so that you all go away from today's call knowing fundamentally what your obligations are because you know the role that you play within getting that product to market. And then we'll talk about, in the absence of this perfect kind of set of this standard that lays out, how we must design and manufacture goods and how we must test them. We don't have that for GPSR because it's such it's a regulation that has such a broad scope because it covers all general products, and it even covers products that may already be subject to other regulation, like products that carry the CE mark also fall within GPSR. So in the absence of that lovely kind of bundled up nice little standard, what are we meant to do? How do we demonstrate that our products are compliant? And the regulation refers to safety requirements that we have to consider. So we'll cover those off so you know what you're looking at. And then we'll talk about that practical approach to compliance. So what is it that you actually need to do? What are they talking about when they talk about a technical file? What are they talking about when they talk about a product safety risk assessment? Is that something that you need to pay somebody else to do, or can you do it yourself? How do you label your products to make sure that customs and authorities in the EU know that they're compliant with GPSR? And then there's some other stuff in there in terms of the SafetyGate portal. I'll explain where that sits in terms of compliance. And that's really something that, unless you're a geek like me that has to have the regular weekly updates as to unsafe products on the EU market, your interaction with the SafetyGate portal may only be required if you're alerted to the fact that your product a consumer has logged a safety issue with your product. That's when you'd interact with that portal and you'd have to log your safety issue. We'll cover that off. I've got a special slide on it. We're recording the session, so we will make sure you've got a recording, and I'll forward the slides to you as well, those of you that have attended. It just means that focus on maybe what I'm saying today rather than making, spurious notes, because you'll have the recording and you'll have the slides to refer back to as well. So Where does GPSR sit in the wider EU regulatory landscape? Well, we've broken it down into 3 bits here. So you've got the vertical regulation. That is all, if you're sat at your desk at the moment and you looked at the charger for your laptop or something, you'll see that it has a label on it that carries the CE mark. Or if you nipped into the kitchen and switched on the kettle, you'd see the label on the kettle flex has got the CE mark on it. That is because those products have to comply with the low voltage directive. And that's one set of vertical regulation that the EU has that means that manufacturers have to test their product, design, manufacture and test their product to a very specific standard before applying the CE mark. EU GPSR has an impact on those CE marked goods in so much as there's probably really 2 key areas. The first one is that those companies that have CE marked goods will have technical files for those CE marked goods, and that technical file must include an internally conducted product safety risk assessment, which historically it didn't need to have. And then secondly, we have been handing out or sending our products into the EU with manuals or user guides in English in the past. And where the goods are CE marked, just CE marked, those manuals and user guides now need to be translated into the language of the member state where they're going to. They're probably the 2 main impacts that EU GPSR has on CE marked products. So that's why we talk about GPSR extends the compliance requirements on CE marked goods. There's a set of regulation here, so vertical regulation excluded, that GPSR has no impact on at all. These products, so medicinal products, food and feed products and so on, are completely out of scope of GPSR. That's probably because those products already have very stringent regulation to comply with already. Where GPSR does have a significant impact is on what we call this horizontal regulation. I've put in brackets repealed. So it repeals or it replaces, GPSR replaces the old General Product Safety Directive, which is on which the UK's Product Safety Act is based. Now, the old General Product Safety Directive, I think, came into being in 2002, and its hard implementation was around 2005. That is now replaced by EU GPSR. Remember that Great Britain hasn't got the equivalent of GPSR. So if you're on this call today and you're just selling into England, Scotland and Wales, then you need not worry about GPSR at all. GPSR covers Northern Ireland, the 27 member states, and what we call the EEA markets, which are Norway, Iceland and Liechtenstein. Okay, so that's where GPSR sits. So it replaces the old General Product Safety Directive, and it replaces the old regulation that refers to food imitating products. So if you're sad like me and you read the GPSR regulation from back to front, great bedtime reading, then you will notice that there's a section in there about food imitating products, and that's because EU GPSR replaces that old directive that covered those type of products. Okay, so that's kind of like where it sits within the whole product safety regulatory landscape in the EU. Why now? Why now, essentially? So, you know, we had the General Product Safety Directive. All of the member states, including the UK, had transposed it into their national law. So we've got the General Product Safety Act. Germany has Prod SG and so on. So they've all got these individual Product Safety Act derivatives. Well, essentially, when the regulation first came into force, there wasn't as much online purchasing of consumer products. So you remember back to kind of like 2002, Amazon existed, but it was purely a bookshop, right? Whereas Amazon is this monolithic giant thing now that you can buy everything from. And it is a very popular route to market, and the old General Product Safety Directive didn't cover consumers for that online purchase of their goods, if you like. Similarly, back in the early 2000s, there wasn't the amount of digital technology now. So, you know, we have physical goods now that have digital components, Xboxes, things like that. There was no cover in the old directive for new digital components, and obviously they pose risks to consumers as well in terms of malware and cybersecurity and so on. So the new regulation covers consumers for that digital content as well. Similarly, the old regulation didn't have, it placed all of the obligation for withdrawing product from the market almost solely on the manufacturer. It didn't account for the fact that there are other players like distributors and resellers in the supply chain that can actually assist the manufacturer to pull that product back into conformity. And then other things like, for example, when, and I don't want to get too involved in this, but when you hear the EU refer to a directive versus regulation, a directive is issued by the Commission, but it allows the EU member states to transpose that into their own national law, and they can make significant changes to it as they transpose it into their national law, which is why we have this kind of patchwork effect of regulation across the EU. And it's really difficult for countries like us, like GB now, to be able to comply, because we're complying with different variations of the same regulation across the EU. Now that it's regulation, that's much more stringent in terms of what member states can do. They can make it slightly more stringent, but they can't dramatically transform the regulation the way that they could as a directive. So the fact that it's regulation places it more at the EU Commission level, and there's less scope for regulatory creep, as we call it. So it should, longer term, become easier for us to comply with. In terms of what's in scope, so we've talked about those CE marked goods. There's an error there, I do apologise for that. That should be CE marked, not market goods. Those CE marked goods are impacted minimally because, you know, they're already complying with very stringent regulation. It does importantly cover kind of goods that might have been designed for trade or professional use, and similarly second-hand products that might have been repaired, reconditioned or recycled. Similarly to the way that, you know, we now buy a lot more stuff online, there's also the proliferation of these websites like eBay and so on that allow us to buy second-hand goods. So goods that might have been originally designed for trade, those trade professionals can now sell on their old equipment when they buy new equipment. They might put that for sale on a second-hand marketplace, and therefore it falls into the hands of consumers. So you also always have to be minded as manufacturers, okay, I'm selling this product essentially for trade and professional use, but there is a chance that it may end up in the hands of consumers. So you should always be looking at those safety requirements through the lens of GPSR. Now, we say it excludes B2B sales. I'm going to give two examples of where B2B sales are excluded. So if, first of all, where they're not. So if you're selling consumer goods, but you're selling to a business like a distributor or a reseller, they, even though you're selling them to a business, the fact is they're consumer goods, so they are within the scope of GPSR. However, if you're sat on this call today, and I usually like to see who's attending the calls, but I didn't have a chance to see who you all are, but if you're sat on this call today and you sell products into the EU to a business that's only going to use those for its own commercial use, then they are out of the scope of GPSR, because that business will conduct its own safety risk assessments for any equipment that its employees use. However, on that same train of thought, if you were selling goods to a business that could then kind of make them available, and I mention this because we deal with companies that might sell to hotels. So I'm thinking about artwork here. So we deal with a number of artists that sell their goods to a hotel, but then that hotel may make those goods available for consumers in their lobby to buy, for example. Then that falls within the scope of GPSR. And similarly, you know, artists that are shipping to galleries, for those galleries not just to exhibit that artwork, but also potentially to sell it, then GPSR needs to be considered then as well. But if you are selling just to a business who is going to use them within their own commercial environment and never sell to consumers, then that's out of scope. The second example of when a business transaction might be out of scope is if you're selling a raw material or a component part that business customer is going to incorporate into their own finished product, even if that finished product is going to be sold to a consumer. It's for your business customer to make sure that finished product is in scope of GPSR. You become an upstream supplier or an upstream manufacturer in that scenario. I can cover questions off at the end if any of you are still uncertain about that. Obviously, we've got medicinal products, food and feed and so on, the kind of the usual suspects, as I call them, the ones that typically fall outside of this kind of regulation, they're totally excluded. And services are excluded as well, which is, if you're 100% services sat on this call, then you can probably hang up now. That's one area of regulation that you don't need to worry about being GPSR. Now, notable points within the regulation, you might have heard people talking about economic operators. Economic operators is just a catch-all phrase, right? That because the regulation mentions manufacturers, importers, distributors, authorised representatives, it doesn't mention traders, sellers, other, variants of companies that get that product to market. So economic operator is a catch-all phrase to make sure that everybody knows that if they're managing the product in some shape or form to get it to the consumer, then they're an economic operator and they have a duty under GPSR. You'll have heard reference to an EU authorised representative or a responsible person, and the two terms are used interchangeably, rather annoyingly and rather confusingly. If you imagine responsible person is the umbrella term, okay? That is the EU. The EU implies that any regulation that's adhered to, any EU regulation that's adhered to, the EU likes to have an appointed business or individual in the EU that it can reach out to in the event of any regulatory breaches. It doesn't want to be chasing a manufacturer across the other side of the world. So the EU increasingly, with its regulation now, insists that any manufacturers based outside of the EU appoint a responsible person. Now, an authorised representative is just one variant of a responsible person. So you potentially could have your importer act as your responsible person under GPSR. Some companies might be doing it, others find that it creates sensitivity because they'll have more than one importer and they don't want one importer's details appearing on the labelling for products that end up being distributed by other importers. It's just a little bit sensitive. But an EU authorised representative is an entirely separate body. So Global Trade Department operates as an authorised representative for the EU for small micro and SME companies. We offer that service, but we're completely independent from our clients. We're not their importers, we're not their distributors, we're not involved with them in any other way other than we're an authorised representative. And that's so authorised representative is a kind of responsible person. Hopefully that clears that up. Also, the regulation introduces the EU Safety Business Gateway that some of you have never probably had to deal with before. That's the platform that sits at the heart of product safety compliance in the EU. And it allows you as the manufacturer, if you're alerted to a product safety issue in the EU, you can log that issue on the Safety Business Gateway. You just log it once and that fires off a notification to all of the different regulatory or notified bodies across the EU. And when I talk about those, I'm basically talking in this instance as the EU member states equivalents of our trading standards. Okay, they all have their variations. And the business gateway, the Safety Business Gateway, basically takes your notification and makes sure that all of the relevant notified bodies are notified of that safety issue. The regulation GPSR actually imposes, and this caused a lot of angst at the beginning part of this year. I think there were two things that really hit our SME community badly with GPSR. I think one was the need for an authorised representative, and the costs that some companies were being quoted was just ridiculous and really, really unfair. And secondly was the translation requirement. So I want to be really specific here about what translation means. So If your products are not CE marked, you are only obligated to translate the safety instructions for the product. So I'll make an example here. So we have a lot of greeting cards manufacturers that use our system to be GPSR compliant. There aren't many safety risks of a greeting card. So where there aren't any safety risks or warnings that need to be included on the packaging or on the product, then there simply aren't any, and so there's nothing to translate. However, your warnings or safety requirements are the output of your product safety risk assessment, which we'll cover off. And it's just those warnings, it might be 1 or 2 bullet points that need to be translated. I would use something like DeepL, which is an AI platform. It's been trained on lots and lots of EU regulation. It works exactly the same as Google Translate does, but it's a lot more accurate. Okay, so you don't need to enlist the services of a translation company, and all of our associates that are in that business would agree. For the sake of these, bullet points, DeepL is perfectly adequate. The regulation has this kind of clause, we call it when a manufacturer is not a manufacturer. So really the manufacturer becomes the brand owner under GPSR. So if you have a product that is made for you and it carries your brand, you are the manufacturer for the purposes of GPSR. Or if you buy a product and you rebrand it as your own, you're the manufacturer for that product. So the actual physical manufacturer of the product becomes your upstream manufacturer that you'll have to get some information from to make sure that you're compliant, but it's you that fulfills the obligations of manufacturer under GPSR. What else? So much of what's in the regulation is stuff that I'm pretty certain all of you on this call today do already, because we are ethical businesses and we treat our customers fairly. So it's things like, if there was a product safety recall and you had to have your consumers return the product to you, you wouldn't expect them to pay the carriage. You wouldn't expect them to be out of pocket as a result of you having to withdraw the product. If you asked your consumer to dispose of a product, you'd only ask them to dispose of it if it was safe and environmentally friendly, for them to do so. So much of it in there is stuff that we're already doing. This regulation isn't really targeting UK businesses because we've been so closely aligned with the EU for so long. We're already very, very compliant, but the EU, like the UK, has been flooded over the last 7 to 10 years with less safe, less sustainable product from further away. I'm thinking of the Sheins and the Temus and so on, and the markets are flooded with it. And regulation is one way that the EU has to try and control the flow of that product. There are penalties for non-compliance, and I have included a slide, but I don't want to be alarmist about it because we've not seen any customs fines imposed as of today. We've not seen any. We've seen some product returned where distributors or importers have said, I can't put this further on the market because it's not GPSR compliant. So yes, there are penalties, as with every piece of regulation, but I've got a slide on it. I don't want to be alarmist about it, it's just for information. So obligations depending on role. As I say, there's a lot broken down in the regulation, and then we've got this catch-all phrase of economic operator that covers anything that isn't explicitly named, if you like. So I'm just going to cover some of them. I'm assuming that the majority of you today on the call are probably sitting within the manufacturer or the producer category. So what are your obligations under GPSR? Well, first of all, you're basically saying that you will comply with the safety requirements when ascertaining the safety of your product or designing or manufacturing your product. And I've got a slide on the safety requirements, so I'll cover those off in a minute. You're committing to carrying out an internal risk assessment. So an internal risk assessment, you don't have to pay somebody to do that for you. They're your products. We at Global Trade Department have templates that you can access to help guide you through that. But the risk assessment is on your product. You're promising to maintain a technical to create technical documentation and maintain that technical file. Again, I've got a slide on what might go in that technical file, so I won't go into too much detail there. We do have to make sure that our products carry what we call a unique identifier, and some of you might already have serial numbers, batch numbers, SKU numbers, and so on. If you think about where the EU is coming from, it helps you, if you haven't got that system in place already, think about what you might use as that unique identifier. What the EU is trying to do is to make sure that if there was a product safety issue, you could isolate other potentially impacted product as well, and only withdraw a certain amount of product from the market rather than everything you've sold. So have a think about, if you don't have a kind of batch system in place already, then how could you implement one, and what would that look like? Your products, and when I say products, we also have the flexibility at the minute to put a lot of this information on documentation accompanying the product or on its packaging. So you don't have to, we've got jewellery manufacturers that are selling stud earrings on tiny little cards like that. They can't possibly put that on the product itself. So therefore, they send the product with documentation, or they've amended the packaging to include this detail. But you must include, in addition to the unique identifier, it must have the product or its packaging or its documentation must carry your details as the manufacturer, and that is your trading name, your postal address, and your electronic address. And we always say to clients, we prefer email because it ticks a couple of boxes rather than just giving the contact page or the website address, even though electronic address could be your website. So I would say trading name, postal address, and email of a manned email box, say contact at or info at. Where you are working perhaps from your residential address, which a lot of small businesses are, and you don't want that physically on the product, if the postal service like Royal Mail can identify your location by just your trading name, your city, and Great Britain, then that's perfectly adequate. We can not condense, I can't think, abbreviate our address if you don't want your residential address visible. So you've got your unique identifier, you have got your manufacturing details, second piece of information. Then you've got your safety information, which will be the output of your product safety risk assessment, and that must be in the correct language. And then your responsible person, whether that be an authorised representative or your importer, for argument's sake, then their details, their contact details must follow the same format as yours. So trading name, postal address, and email address. And where you appoint an authorised representative, even if it is your importer, then there must be a formal mandate between you and them that clearly outlines their obligations and your obligations. So when we're contacted via the authorities for one of our clients, we not only have to give the authorities the technical file for the product that's in question, but we also have to produce a copy of the mandate that shows that we have a formal agreement with that client and we are mandated to operate on their behalf. You're also committing to, if there is a product safety issue, that you'll withdraw it from the market in the quickest time possible, that where you know who the consumers are, then you will contact them directly, which is obviously easier via an e-commerce situation. But if you don't know who the end customers are, then you'll notify your distributors, your resellers, and so on. And similarly, you will make an announcement via a platform that has the greatest possible reach. So you might put something out on social media, or and then similarly you have to notify the Safety Business Gateway as well. So you're basically confirming that you will comply with the regulation in terms of those different steps if there is a product safety issue. And then there is so much with international trade and regulation compliance, there's always a documentation requirement. So if there is a product safety issue, you're committing to investigating it thoroughly, and you maintain records of that investigation for no less than 5 years. This is all stuff that I'm pretty certain you're all already doing, okay? But it's just general product safety regulation just makes it very explicit so that we're all very sure what our obligations are. I've bundled importers and distributors together fundamentally because they're quite often the same. However, the regulation allows an importer to operate as a responsible person, but not a distributor. So you have to be quite clear if you want to appoint one or your sole importer, then they must be the importer of record to be able to hold your technical file. And I think that's also why some clients have preferred to appoint an authorised rep, because they don't want their technical file holding all of that important product information, but perhaps also details of their upstream suppliers and manufacturers. They don't want that information in the hands of their distribution network, if that makes sense. Importers and distributors, their roles are slightly different. So they have to keep you as the manufacturer compliant, so that they basically are not permitted to place any product on the EU market that is not GPSR compliant. That's when I mentioned before that we've seen some product returned to manufacturers where the distributors have said this isn't compliant, I can't sell it on, it needs to be relabeled. So they are making sure that anything that they import is compliant with GPSR. They're also obligated to help in the event of any product recall. So they would be helping you as the manufacturer to notify relevant parties to get that product returned as quickly as possible. And they have to make sure that while the product is in their care, nothing from a transportation or a storage perspective can impact that product safety. Okay, so they've got lesser obligations, but they have obligations, which is different to the old directive where it was all kind of like down to the manufacturer to sort out. The authorised representative, so this can be, it's really important to mention that this can be what we call a natural person, which is an individual, or it can be a legal person, which is a company, and they must be established within the EU, or the territory where the GPSR is in place. They are, it's not something I would give to a relative or to a best friend that just happens to be residing in the EU, because there is an obligation to understand the regulation and to make sure that your technical file that you log with them is compliant, that everything's in there that should be in there. So it's a little bit more involved, and there is kind of like a longevity to the relationship. So from the technical file has to be available to the market surveillance authorities for some 10 years after you've finished selling the product in the EU. So there's a longevity there, if you like. But you are perfectly within your rights to apply to appoint an individual in the EU, an individual residing in the EU, or a company established in the EU. That's perfectly acceptable under market surveillance regulation. There must be that mandate between you and them. They must have an up-to-date copy of your technical file at all times, and they must make sure that that is provided to the market surveillance authorities within the time window that they've given. So depending on the severity of the product safety issue, that window might be really quite small, if that makes sense. Like I said, under no obligation to even speak to us about our authorised rep service, but we do offer it for micro businesses, so 9 employees or less, or SMEs up to 250 employees. So you're very welcome to book a short call with us to understand a little bit more about the process. One thing I should have mentioned earlier, and don't be persuaded that this isn't the case. You can group your products together for the purpose of GPSR. So Global Trade Department, we have a number of large jewellery manufacturers that use our service, and they might have 16 to 18,000 SKUs, so individual variants of their products, lots of different earrings, lots of different bracelets. But when they've grouped their products together according to our methodology, they've ended up with 20 to 25 products from 18,000 SKUs, which is brilliant because it means 20 to 25,000, 20 to 25 product safety risk assessments and 20 to 25 technical files, which is a lot more manageable than 18,000. So when we're getting clients to group their products to ascertain their work to pull all this together, and similarly, if you got quotes from an authorised rep, they'd ask you how many products you have, then we ask them to group their products according to purpose. So what is the product? composition, so what's it made of, and then risk profile. Now, we only include composition because as regulatory specialists, we're always looking at regulation that's coming down the line. So, you know, we're heavily focused on the Eco Design for Sustainable Products regulation that's going to impact textiles and all general products eventually. And a lot of that will be based on composition and certain, you know, the kind of circularity of products and recyclability of products. So we don't want our clients grouping products together to comply with GPSR only to have to do it all over again to comply with future regulation. So that's why we say composition. But you could just do what is the product and what is its risk, and then group them together that way. Motoring on, online marketplaces, they've got their own level of regulation to deal with. A lot of you might only have become aware of GPSR originally because you had a notification from eBay or Amazon as they tried to get their ducks in a row, but their obligation is more around making sure that their traders or their sellers are compliant, and then removing sellers that are, you know, continuously non-compliant, or any unsafe product they have to mark as unsafe or remove from the platform. But they've got a lot of other stuff to worry about. I want to move on to the safety requirements because we talked about that lack of a standard to design, manufacture and test our products against. So let's focus on the left-hand column. So we've got product characteristics. The regulation asks you to look at your products, and it asks you to compare your products with other products. Look at the impact that your products have on other products and the impact that other products have on your products. Now, one example I often use with clients is I'll say, okay, imagine that you're designing and manufacturing a device, whatever that device might be, and you ship that device with your own charger. The consumer gets your device and charges it with another charger that's not yours. That device might charge more slowly because they've used a different charger. That's a quality issue. However, if as a result of them charging that device with another charger creates an electrical fault or a shock or something like that, or a spark, then that's a safety issue, in which case you might want to mitigate against that by making sure that you state clearly on the product or its packaging and documentation that the product must only be charged with the shipped charger, the charger that's shipped with it, or a I can't remember the exact term, but your charger. That's the kind of thing that it's asking you to look at. And it's also looking, you have to think about the different categories of consumer. So this is new in the regulation as well. The old directive just referred to the consumer, but this regulation asks us to think about, we might be shipping our product to an able-bodied adult, okay? But what happens if our product falls into the hands of a child or an elderly person or someone with disabilities? The regulation actually goes down to make a difference between genders as well. So, you know, it might be aimed at a male, for example, but are there any additional material risks of a woman using that product as opposed to a male? So it really asks us to think about those different categories of consumers. And then it asks us to think about, is the product appearance misleading? So does it look like a toy, but it's not a toy? Does it look like a food, but it's not a food? And where you've basically considered all of these and you have labelled the product accordingly, so, you know, if it's only to be used with the factory fitted charger, then therefore you state that. If it's not a toy, but it looks like a toy, then you make sure that it's, you know, not suitable for under 14 or not suitable for children, that kind of thing. When you've done all of the left-hand side, then you've got what's called the presumption of conformity with GPSR. So you've done all of this, you've got your technical file, you've done your product safety risk assessment, and you've labelled your product correctly, then you've complied with GPSR. Stuff down the right-hand side is if you are voluntarily complying with any kind of regulations. So, you know, you might not be obligated to comply with certain standards in the EU or international or British standards, but maybe you do. Then they're all really good stuff that demonstrate that you take the design and the manufacture of your product really seriously when it comes to safety. So that's all good stuff to put into your technical file, but it's not necessarily mandated as part of GPSR compliance. Focus more on the left-hand side. Your product safety risk assessment, as I say, we've got templates. This sits at the heart of your technical file, right? This is the first thing. So when we're talking to clients, one of my colleagues is talking to clients and they're in a hurry to get compliance so they can continue selling. Fundamentally, the product safety risk assessment sits at the heart. That's what we'll push you to do first. And that is, we've got templates, we've got pre-filled templates. So I've got templates for all sorts now, from jewelry to apparel to all sorts, that we can share with you that just helps you understand the kind of stuff that should be in your product safety risk assessment. Okay. UK Gov has their own PRISM methodology as well that you might want to look at, but to be honest, I think our templates are just as good, if not better, to be totally honest. So after the call, if you want to book a call with us, or if you just want to pop us an email, feel free and we can send you out templates that will help you do this. But this is the most important part of your compliance, is that product safety risk assessment. Your labelling, not suggesting for 1 minute that any of you use this but ugly label here, but it does include the 3 to 4 pieces of mandatory information that go on the product or on its packaging or on documentation accompanying the product, which for argument's sake could be the commercial invoice if you're shipping e-commerce, for example. So again, it's your details, your authorised rep details, that product reference that we talked about, and those, when I say kind of 3 to 4, the any safety instructions, you know, if there aren't any, you can't just make them up for the purpose of GPSR. So if you've got very, very low risk products, then you might not have any safety instructions or warnings at all. And just a word of advice, you can tie yourself in knots thinking about all the different ways that consumers could use your products and cause issues. We have to be mindful here. This is about intended use. So yes, consumers can do all sorts of silly stuff with our product, but the regulation is asking you to think about intended use. So don't tie yourself in knots when doing your product safety risk assessment. But as I say, this is just a very basic example of a label that includes that mandatory information. Your technical file can sound really scary if you've never had to think about a technical file before. The regulation even has a clause in there that alludes to the fact that very low risk products are going to have very small technical files and very small risk assessments. You know, your technical file and your risk assessment will be proportionate to the risk that your product poses to the consumer. So we can't just make stuff up for our technical file for the sake of it. But the things that certainly Global Trade Department has its own technical platform, if you like, and that we've developed to help our clients. And the process of going through the platform helps you create your technical file. So if you've answered all the questions and appended the right information or the right documents within the technical file and the output within the platform, then the output is your technical file that we then go in the back end and validate and so on. But the things that our platform will be asking you for is kind of like manufacturer details, any third-party supplier details. We track kind of like the SKUs that might make up your product categories, where there's any where your products are subject to any other information, any other regulations. So say, for example, apparel, for argument's sake, may have to comply with REACH regulation around dyes and so on. Then you'll have the opportunity to append those kind of statements or compliance documents from your upstream manufacturers and so on. And then we also insist that our clients include a copy of their labelling or a picture of their labelling, because what we want is to make sure that in the event of a product safety issue, if we're contacted by the authorities, we can give them the technical file and they can see very clearly at that point the product was being shipped with these instructions. And if the consumer has used them, you know, to the contrary, or has used them in a different way, and that has brought light to a product safety issue, that's kind of, you've done the best that you can. And obviously by taking a photograph or an image of the labelling, we can demonstrate that to the authorities on your behalf. And as I said before, your authorised rep keeps that technical file, that up-to-date technical file, and should only be giving a copy of that technical file to the market surveillance authorities. They cannot give it to consumers or distributors or anybody else. It's just the surveillance authorities. I'll skip this one. This is the boffins that create all the product safety regulations. So these are the people to take a contract out on, I should say that. they have a very important role to play. And they do publish the minutes of their meetings. I'm not suggesting you look at them, but obviously the likes of ourselves, we have to dip in and out of them. But these are the guys really that are following the implementation of GPSR, and you know, these are the guys that hopefully, with the introduction of digital product passports, will say actually it's not going to be a requirement to physically send all of this documentation and everything with the product. We can get away with a QR code that we've certainly been lobbying for since the regulation came into force. But these are the guys that are monitoring the implementation and looking for the difficult parts and how it can be tweaked and how it can be improved. The SafetyGate portal, like I say, those sad ones like me do subscribe to the weekly updates. I think the only real requirement for businesses like yourselves to subscribe would be if you're a manufacturer and you have component parts within your finished goods and you know that those component parts might be used by other brands as well, it might not be helpful to be alerted to unsafe products. Obviously, you can really condense down the scope of what comes to you via email. You know, you can select certain products and so on. But you might want to be alerted to the fact that a specific component has a fault or has been registered as unsafe, because you might use that component as well, and you might want to proactively obtain which batch was impacted and so on, and whether your finished goods are impacted, so that you can proactively deal with your product as well. That's probably the only real reason why I would suggest that any of you subscribe to that. The other side of the portal is where you've been alerted, or your distributor or reseller or so on has been alerted to a product safety issue relating to your product, then this is where you would log. You'd create a profile, you'd log the issue, and then, like I say, that notification gets fired off to all of the different market surveillance authorities, so you're only logging it once. This is where I said there's penalties. Yes, okay, so we know every piece of regulation that's given out has penalties, and it all sounds very scary. You know, when we're talking about 6-month custodial sentences and €200,000 fines, that's gross negligence, that's gross fraud. That's where you have deliberately withheld information from the consumer that's put their welfare in jeopardy. We haven't seen any customs fines as a result of GPSR, and we deal with hundreds of businesses with GPSR. I would imagine, you know, we're 12 months in come December, maybe next year, for repeated kind of non-compliance, customs may start to impose small fines of 50, €70. But I think the biggest thing is having the product returned to you when it's not compliant, because that has costs associated with it as well. So I think, you know, irrespective of the fines, let's just get compliant as quickly as we can. Who polices this? Essentially, it's the market surveillance authorities in the EU fundamentally that are responsible for this. So, you know, similar to here in the UK, they do audits of distributors and importers' premises to check product is compliant for the EU marketplace. But I think customs, from our perspective, obviously we've got to get the product into the EU in the first place. So the kind of term of placing on the market is getting the product cleared for free circulation in the EU. So we've got to get past customs, and customs are always the eyes and ears of market surveillance authorities. They will pull product if they're in any doubt, and then they'll check with the surveillance authorities. Sometimes it'll be fine and they'll release it, or sometimes they'll return it to the UK or notify the exporter in the UK that it's not compliant, and then there'll be actions, you know, follow-on actions. So really it's customs in the first instance, and then once the product's on the market, then it's subject to scrutiny by the market surveillance authorities or trading standards. So that's really it. This final slide is just talking about back end of last year, beginning part of this year, the world was in a tiz. For us here, it felt like Brexit Mark II, to be honest. It was horrific. There are so many small businesses that you know, the EU is an important market for them, and they were hit by GPSR, what felt left field, because it wasn't very well publicised. And we just want to avoid any regulation, be it EU or global regulation, coming down the line, we want to absolutely avoid that having the impact on small businesses here in the UK like that again. We don't want to be in that position. So we have regulation mapped out to 2040. And we're actively working on it all the time to understand what it means for small businesses. All we're saying to small businesses is, if you don't use us in any other capacity, you don't have to employ us to do anything or pay us any fees. But if you want to opt in just to get notifications of what's coming down the line, some of it might be important and irrelevant to you. Some of it you might think, I'm not in that sector, it doesn't have any impact on me whatsoever. We're just trying to make sure that you're ahead of the curve. Because when you're ahead of the curve and you know what's coming, you have time to comply, you can cost effectively comply, and you don't make knee-jerk reactions like switching off shipping to the EU, which a lot of small businesses did in December last year. Because I think there's something about Brits, particularly whenever anybody mentions regulation or compliance, we're like, and we panic until we know we're compliant. And that's just so damaging to our revenue and our reputations and our kind of profitability from sales into the EU. And then the final thing is, so opt-in, if you're interested in getting those updates and invitations to webinars that we do regularly, free webinars that we do on certain regulation, just opt in at contact@globaltradedepartment.com. And then if you're still unsure after anything that I've covered today, then you're very welcome to book a free one-to-one session. I've given the link there. And then the webinars that I referred to just a second ago are all on our homepage, so you can sign up there. And then without taking up any more of your life that you'll never get back,